Okay, let's get started. My name is Jay Stansel. I'm on the board of the Benefits Law Center. I previously to this spent 26 years as a public defender in one form or the other, including 19 years. My last time as a defender was in 19 years as a federal public defender. But I know many of you, I think, out there from my days in state court as well. And I'm just here in support of BLC, but also really impassioned about its mission. As a defender, at one point in time, my office and a team of us had a client who was schizophrenic, and much of our good efforts to settle the case appropriately had to do with articulating how much his untreated mental health had to do with his crime, and we substantially mitigated the case. But then came the question of, like, what's going to happen with our guy when he gets out of prison in his vastly reduced sentence? And so I reached out. We found Alex Doolittle, who is now the executive director of BLC, and started a now many years long collaborative process with BLC on helping folks once I'm done as a defender with their case. And so that's my theme of the importance of this for public defenders and defense attorneys in general, is what's going to happen when I'm done with the case? How is my client going to survive? So that's, we put this together, this webinar. Thank you for coming. It now has official CLE credit awarded by the Washington State Bar Association. We have a colleague from Massachusetts, hooray, Eileen, and welcome. I don't know what you do. Maybe you could still get a credit of CLE credit somehow, but the CLE number that you'll search for on the WSBA website when you go to report this credit is 1176744. That's 1176744, and that's you'll also have in your chat. I imagine all of you have used Zoom before in this during this pandemic time. And in the chat, at the very top of the chat, is that WSBA number that you can go back and reference. We are recording this webinar. So a recording, a link to a YouTube recording of this webinar will be sent to everybody who registered and signed up for it. So don't worry about taking notes if you don't want to. You'll get the visuals as well. Post-webinar questions should be addressed to Becca, who I'm going to introduce here in a minute. And the last thing to say is that, please, this is a free CLE. We're really happy that you're here. It's important stuff for all criminal defense attorneys to know. But we do obviously encourage your further engagement with BLC in the form of donations and helping to support our work. You can text at any time the number 44321, and just with the message in caps, give, G-I-V-E, numeral 2, BLC. So give to BLC, all in caps. That also is at the front of the chat. The final thing is, I guess, put your questions into the chat section, and I will monitor the chat, and periodically Becca will pause, and we'll get a chance to ask those questions as we go. Okay. So without further ado, let me just introduce Becca. Becca Maloney is the staff attorney at BLC. She began in January of 2019. She graduated from the Metropolitan State University of Denver with a BA in Philosophy and Women's Studies, and then went on to get her JD at the University of California, Irvine. Since coming to Seattle, Becca's volunteered at various public interest organizations providing legal advocacy and protection to the most vulnerable people in our community. She's passionate about using her law degree to provide BLC's clients equitable access to vital benefits, and we welcome her work with BLC. So I'm going to mute myself, and Becca, take it away, please.
Thanks for that, Jay. So today we're talking about collateral consequences, the intersection of Social Security law and criminal law. I'm going to talk about a few things today, starting with a little intro of who BLC is, followed by the types of benefits that we're going to be talking about, then some statistics about disability, poverty, and criminal justice involvement. And lastly, we're going to talk about what happens to benefits when someone is incarcerated. Okay, so we were founded in 1997. The Benefits Law Center helps individuals with disabilities who are living in poverty gain a measure of income stability, which is the first step toward stability in housing, medical treatment, quality of life. Who we are, we have, at the moment, 4 attorneys, 1 paralegal, our director of development, our executive director, and a whole host of volunteers, including our board, people who help us with our fundraising, people who, boots on the ground, help us with our legal work. These are the basic types of disability benefits that we're going to be talking about today. We're mostly going to be discussing SSI and SSDI. SSI, or supplemental security income, is for individuals who meet income and resource limits and medical eligibility requirements. For this particular benefit, there is no work history required. The next is Social Security Disability Insurance, or SSDI. This is the benefit that most people are talking about when they're talking about, air quotes, Social Security. If it's not retirement, it's usually this particular disability benefit. This is for individuals who have earned enough work credits and meet medical eligibility requirements. For this benefit, work history is required. Lastly, disabled adult child benefits. We're not going to be discussing a lot today, but this is a benefit for adult children who became disabled before they were 22 years old and have a parent who is receiving retirement or disability benefits. So who specifically qualifies for SSI? SSI is a means-tested program known as a program of last resort. It is for people who are age 65 or older, blind, or meet Social Security's definition of disabled. And for those who don't know, Social Security's definition of disability is the inability to do any substantial gainful activity by reason of any medically determinable physical or mental impairment, which has lasted or is expected to last for at least 12 months, or which is expected to result in death. So if somebody meets that definition, has limited resources, less than $2,000, and that's cash, bank accounts, assets that can become liquid, has limited income, and I mean very limited income. Income is reduced or SSI benefits are reduced for any income at all. Then they might qualify for SSI, and the federal benefit rate for SSI for 2021 is $794 for an individual. So not a lot, or it's $1,191 for an eligible individual with an eligible spouse. So even less money for 2 people. And who qualifies specifically for SSDI? For SSDI, somebody has to, again, meet Social Security's definition of disabled that we talked about on the last slide. And for SSDI, somebody has to have sufficient work credits. This is based on total yearly wages up to 4 credits each year. In 2021, 1 work credit is exactly $1,470. So if somebody makes $1,470 in 1 quarter of the year, they earn that work credit. For somebody who's age 31 and older, you have to have 40 work credits in order to qualify for SSDI, 20 of which must have been earned in the last 10 years. So somebody has to have worked any 5 of the last 10 years. And the amount that a person can receive in benefits is determined using a calculation based on an individual's actual earnings. So there's quite a bit of variance on the amount of money that somebody could potentially receive through SSDI. And that's all I'm going to talk about for the rundown of the basic benefits. Does anyone have any questions about the benefits right now?
Okay, just no questions yet, Becca, but this is a good reminder, good time to remind folks. Just type your questions into the chat, and I'm monitoring that as we go. So please chip in as it comes. Okay.
Great. So now we're going to talk about the intersection of disability, poverty, and criminal justice involvement. And people with disabilities are disproportionately represented in jail and prison populations, both jails and prisons. An estimated 30% of all incarcerated individuals report having at least one disability, compared to about 26% outside of jail or prison settings. So it's a significant increase in representation inside jail and prison settings. And of all those in state and federal prisons, more than 52% age 55 to 64, and more than 68% age 65 or older report at least one disability. So as people advance in age, the likelihood that they will have a disability in the prison increases exponentially. Here's a graphic of disabilities that people have. This is self-reported disabilities for people in state and federal prisons in 2016. This comes from the Bureau of Justice Statistics survey of prison inmates. So as you can see, out of all disabilities, a significant number of them are cognitive disabilities, and these include learning disabilities, ADHD, ADD, and this survey also included as a disability people who were told by medical professionals that they have a learning disability or ADD and maybe didn't get a specific diagnosis. So these stats are a little bit skewed, but I think it's representative of people in prisons. So why are people with disabilities overrepresented in prisons and jails? There are a variety of factors. Policies often needlessly criminalize behaviors related to disability. And this could be substance use, people who are self-medicating, homelessness, people who can't maintain permanent shelter or don't have the option to maintain permanent shelter for whatever reason, and atypical reactions to social cues. This is pretty common when somebody with a specifically mental health disability, it has an interaction with police. Their reactions to social cues could be considered dangerous or atypical in other ways. And people are often seen as maybe somebody who's reacting to internal stimuli could be considered to be disorderly or dangerous on the street, and therefore have higher percentages of run-ins with police. People with serious mental illness are more likely to be arrested multiple times for the same crime, spend more time in jail before adjudication, serve longer sentences, and have higher recidivism rates than those without mental illness. And there are a variety of factors at play here. People with a disability who are unhoused before confinement often have difficulty developing solid discharge plans, even when they're eligible for discharge. So they can be held much longer until an acceptable plan is in place. For recidivism, I think it's a pretty important statistic to note that up to 81% of incarcerated individuals with a mental illness have been previously incarcerated. So that's a huge number. And financial stability through public benefits, increased chances of finding stable housing, medical care, and access to food upon release. It's important to remember that the intersection of criminal justice, disability, and poverty not only affects the justice-involved person and their family, but also all the systems involved in their care. So treatment, housing, employment, supervision, etc. This is a fascinating chart from the Prison Policy Initiative. According to the Prison Policy Initiative, there were about 746,000 individuals confined in jails in 2020. And of those individuals, about 74% had not been convicted of any crime. So that's 74% of the people confined in jails that have not yet been convicted of any crime and potentially won't be. 9,000, roughly, of these individuals were held for psychiatric evaluation or treatment. This one is very closely related to disability. People waiting for a hearing or trial can cycle between state hospitals or other psychiatric facilities and jails for years before their case is adjudicated. So someone who is arrested, as example, someone who's arrested during an acute episode, go to the hospital, go to the state hospital or psychiatric hospital, are put on meds, stabilized, released back into the jail. Maybe the meds that they were on that stabilized them aren't approved for use in the jail. So they're taken off their meds, they have another acute episode, they go back to the hospital. And this cycle can go on for years before they finally get in front of a judge. It's also important to note that people are often confined to local jails before their trials because they can't afford to pay bail. And if you think about the amount of money that bail typically is, this graphic says the median bail for felonies is $10,000. For somebody who is on SSI or SSDI, there's no chance that they're going to be able to pay that. So they will remain confined before adjudication because they can't make bail. And I want you to keep this graphic and these statistics in your mind as we go forward to talk about what happens to a person's benefits while they're incarcerated. This is all going to relate back. Are there any questions about any of this at this point?
Yeah, we do have a question that I might have missed, so I apologize to Susan if I missed it when it came up. Susan asks, does a home count as an asset when as a consideration for these public entitlements?
Great question. A home that a person lives in does not count. If somebody owns a home or any real property outside of the home that they live in, it will count as an asset. But as long as the person lives in the home or on the property, it does not count as an asset. The person can have one home.
But this would, of course, penalize people like in rural communities that might own like another piece of property that's really not income producing, but's been part of the family for generations, et cetera. That would get counted against them, that extra property.
Yes, and these cases, we see these cases a lot in rural areas. We see a lot of foreign property. So somebody immigrates from, let's say, somewhere in the Middle East where they owned a home, still own a home, but they can't live there. They can't go back there. They can't sell it. There's nothing they can do with that property. Social Security still counts that as an asset because they own it and don't live in it. So what we do is we work with Social Security and whatever local government we can get in contact with, where the property is. And we try to figure out a way to prove either that the property is worth nothing, can't be accessed, or they don't own the property. Maybe they sold it a long time ago and there's just no record of it. Maybe they handshake deal, gave it away to their brother if it was co-owned by siblings. So we work with Social Security and local governments to try to figure out a way to either prove that there's no value in that asset or they don't own it anymore.
Another question that comes to my mind, Becca, because it seems like we're doing good for time, is could you give these folks a sense? We have, criminal defense attorneys, public defenders on the line here, where it's a lot of times you're beating your head against the wall, and it's an uphill struggle with many, many cases that come your way. On the other hand, you're representing folks who have no right to representation, and if it's a disability, they are oftentimes mentally disabled through mental health conditions. Yeah, do you have any sense in the work that you do what the difference between like the ability of a pro se mentally ill person to get Social Security SSI versus you guys stepping in and doing the job for them?
So that's a great question. I don't have hard numbers in front of me. I do know that the instances of people getting the benefits that they're entitled to under the law when they have an attorney are much higher than when they don't. And this is generally recognized by at least judges. It's pretty common for a pro se claimant to go in front of a judge at the hearing level on their hearing date. And the judge will sometimes, a good judge will recognize that this person could benefit from representation and continue the hearing, send them out to find an attorney. So even judges recognize that there is a huge benefit in people being represented in these cases.
We got another question regarding folks in Native communities who might own land in collectively with others. Or if they own a share of land, does that need to be counted as income or as an asset?
So there are special rules for tribal lands. And generally, if somebody owns a portion of tribal land, both the land and the income that they receive from that land, sometimes it's quarterly, sometimes it's yearly, it's usually not a lot of money. Generally, those are excluded.
Okay, awesome. Thank you for questions so far.
Sorry, Jay, I can't hear you.
My bad. I just wanted to thank folks for their questions, and and that's it for now, Becca. So moving onward, but folks, keep adding your questions. These are really good.
Okay, so now we get to the really interesting and juicy bits. What happens to SSI during periods of incarceration? So this slide is specifically about SSI. This is the means-based program where asset and income limits are strictly capped. So when SSI recipients are incarcerated for less than 1 calendar month, there should be no impact on their benefits. Keep in mind, less than 1 calendar month could be more than 30 days. So calendar month means from the first day of a month through the very last day of the same month. If someone's arrested and confined on September 10th and released on October 25th, they've been incarcerated for more than 30 days, but less than 1 calendar month. So after 1 full calendar month of incarceration, SSI benefits are suspended. If the person is released within 12 months, benefits can be reinstated upon release. If incarceration lasts for 12 months or longer, reapplication is necessary. One thing that's important to note here that I didn't include is that if someone's released from jail or prison within 12 months, their benefits can be reinstated. the Social Security Administration will not do it automatically. So someone who's released, a beneficiary who's released from jail or prison, must contact the Social Security Administration and present official release documents in order to get their benefits reinstated upon release. It's important to note that these rules specifically center on incarceration time. And the policy reason behind this is that the federal government believes that a person's basic needs, food, shelter, clothing, etc., are taken care of while they're incarcerated. And they think that paying SSI benefits on top of that is basically double dipping or paying for a person's basic needs twice over.
Hey, Becca, one of the questions that Susan asked is a good one, I think. Is if you're a public defender and you've got a client in custody, how does the Social Security or the SSI people know that that person's incarcerated? And is there some sort of balance to talk to a client about that? Like you got a 40, you're going to be in for 60 days. You know, you should tell them that you're incarcerated, but it's up to you. Or is there certainty that ultimately someone will get wind of the fact of incarceration and double back and ask for a repayment of that extra month?
So that's a really good question, and something that we can talk a little bit about more in depth at the end of this presentation. This is one of the areas where I believe Social Security and another agency have a direct way of communication. So Social Security as an organization has access to information about who is incarcerated, when they became incarcerated. They do not have the same sort of agreement or ability with almost any other agency except for in the carceral system. Okay, what happens to SSDI benefits during periods of incarceration? SSDI recipients are eligible to continue receiving benefits until they are convicted of a criminal offense and confined to a penal institution for more than 30 consecutive days. After 30 days of post-conviction confinement, SSDI benefits are suspended. They can be reinstated the month following release. But again, Social Security will not automatically reinstate benefits. So this provides kind of an interesting area of this topic. The rules here center on both conviction and confinement compared to SSI, which focuses only on confinement. And sometimes I see cases, if you'll recall the graphic, many people who are in jail for long periods of time are not convicted of a crime. So occasionally we will see cases where somebody is convicted or not convicted of a crime, but is incarcerated in a penal institution for more than 30 consecutive days. Social Security will see that and suspend their benefits. And so this is sometimes the case where there is plenty of room for advocacy to help that person both get their benefits reinstated and to get benefits that they were due, should have been paid while they were incarcerated.
But so Becca, are you saying so even pretrial detention is treated as like, well, you're getting your 3 squares a day and a roof over your head, so you shouldn't be getting your measly $794 a month into your bank account, right?
Yes, that is true for people who are on SSI.
Okay.
For people who are on SSDI, there must be a conviction.
Okay.
30 consecutive days of incarceration.
Okay, well, that's a really important distinction then, isn't it?
Yes, it is.
Yeah, and so do you guys get involved with, making that argument, saying like, whoa, this person was never convicted. They just kind of got warehoused for 6 months until their dismissal.
Yeah, yes, we do. That is an area that is ripe for advocacy, and I think can be taken care of either on our end or somebody who's already in touch with that person while they're in jail waiting for their hearing or trial. Perfect place for a public defender to make a note and take some steps.
And one other question while we're at it, like, and you may have answered this, or maybe there's no clear answer. So there are a zillion jails and prisons all over the country, both state and federal. Like, how does Social Security agency get and kind of collate that data, or is it haphazard and random?
So that is a very good question, and one that I don't really know the answer to. I suspect that it's pretty haphazard and random. And I think that I know that Social Security offices handle local cases, and as a person moves, their case moves with them to the new jurisdiction. So I suspect that when somebody is incarcerated in the jurisdiction where they're receiving benefits, that's a pretty close tie. If somebody's incarcerated in a different jurisdiction, it might take a little bit longer for Social Security to find out about it, or it's possible that they don't find out about it at all.
Okay, all right, thank you. That's interesting.
Yeah, and these are the things. Is there anything else about, any other questions about what happens to benefits while someone's incarcerated? We're about to move on to slightly different topics. Okay. So the application process for incarcerated individuals, when reapplication is necessary, and this is, again, after 12 months of incarceration, someone must reapply for benefits. When it's necessary, this process can begin up to 90 days before the anticipated release date. This sounds much simpler than it actually is. In some places, there are agreements between Social Security offices and prison and jail staff, where there is like a liaison who helps people apply for benefits when they know they're about to get out of prison or jail and they think that they might be eligible for benefits. The jurisdictions where this exists are very few and far between. I can name maybe 6 off the top of my head. None of them are in Washington. So reapplication beginning before someone gets out is very difficult for somebody who is incarcerated with a disability, particularly if it's a mental health disability. Applicants, when they first try to apply, the best way to do it is to call Social Security. Calling anywhere from a prison phone or a jail phone, not super easy. Benefits can be applied for online, but it's only certain types of benefits, and it often requires a follow-up phone call. So somebody can apply for SSDI benefits online and indicate that they would also like to apply for SSI benefits, but they can't directly apply for SSI benefits online. So just the administrative barriers for someone with a disability who is incarcerated to start their application before they are released from jail or prison make it very unlikely that somebody will actually get an application in. Once they are released from jail or prison and actually have the application rolling, they must provide official release documents from the jail or prison where they were confined. And advocates and attorneys, like all of you on this webinar, can help facilitate this application process. If you have contact with somebody who is about to be released or has a prospective release date, you can provide them information about applying for Social Security and kind of help them along in the process, kind of help facilitate it by making sure they just stay on top of what Social Security asks for and making sure, and it sounds menial, but making sure that somebody has in their possession, preferably more than one copy of official release documents can go a very long way in helping getting someone's benefits either reinstated or get the reapplication through. Okay, so now we're going to talk about a few other potential issues.
Becca, could I ask you a question before you get there?
Yeah.
So we were talking about reapplication or reinstituting the same benefit. What about first-time applicants for SSI or SSDI that are incarcerated? If you've got you're a defender and you've got a client who's mentally ill but has never gotten what they should get, the SSI, to start living on. Is that possible to start that process while they're in custody?
It is, yes. The application process and the reapplication process are essentially identical. The only difference is that Social Security will already have a file on somebody who's applied before. But they're basically identical. And that is actually another, thank you for pointing it out, Jay, that's a big area where defenders and prison and jail staff, anyone who works closely with incarcerated individuals, helping to identify somebody who might be eligible for SSI or SSDI based on a disability could actually go a long way in helping to provide them some sort of financial stability upon their release.
It's great. And so in that sense, defenders are kind of that, it could be very useful first identifiers of somebody who you should be on SSI because you've got this disability and this would be money you could stabilize with, and they could connect up with resources like yours, right?
Yes, and that's particularly valuable for people who maybe haven't been engaging in treatment before their arrest and incarceration. Sometimes we have clients where the only medical records that exist are from periods of incarceration when they were being seen by the prison medical staff, just because they don't have the ability to engage in treatment outside of their incarceration. Didn't before anyways.
And another question popped up that Olivia asks, what if their client is going to work release or a halfway house to complete his or her sentence? Is that still in custody?
So it depends. Whether someone can be eligible specifically for SSI when they're released into either a halfway house or potentially work release depends on how that particular facility is funded. If Social Security makes the argument that the facility is fully funded by the government, it's unlikely that they're going to be eligible for SSI because the government is already taking care of their needs. If it's funded in any part privately, or in some cases, state-funded institutions people are eligible for benefits when they're in them. But it really, really depends heavily on the specific funding. It would be important to note that somebody who is released into a work release program is less likely to qualify for these disability benefits based solely on the fact that if they're released into work release, presumably they're trying to work, which is antithetical to the point of the disability benefits, i.e. that somebody isn't able to work. So at the very least, the adjudicator on that case will look at somebody's attempt to work and make a note of it. It's not necessarily barring, but they'll at least note it. Okay, so a few other potential issues. Cessation of benefits for somebody who's on benefits due to bench warrants. This is something that we don't see very often, but it does happen. So bench warrants specifically for fleeing felons cause suspension of benefits if the warrant is outstanding for more than 30 days. And this suspension can be appealed in a couple of ways. One, if Social Security's information is wrong and the warrant has actually been satisfied. Two, if the person for whom the warrant is issued believes that they have good cause for not satisfying the warrant. And there are a couple of good cause arguments. The first is a mandatory good cause, which can be requested at any time during this process. So somebody who has their benefits terminated due to a bench warrant, they will receive a notice of action from Social Security that says, we see that you have this warrant, we are suspending your benefits as of this date. So for mandatory good cause, it can be requested anytime after they receive this notice. And mandatory good cause will be found when somebody has been found not guilty by a court, charges were dismissed, the warrant was vacated, they were erroneously implicated. And I don't have a good sense of how you can prove that. Or there's some sort of other exonerating order from a court. And that's mandatory good cause. These we don't see very often. Discretionary good cause requests are more common. And these requests must be made within 12 months of the notice of cessation. And discretionary good cause may be found when the offense for which the warrant was issued is nonviolent and not drug related. They have not been convicted of any subsequent felonies after that warrant was issued. And law enforcement reports that they are, from the jurisdiction, reports that they are unwilling to act on the warrant. It's pretty specific circumstances. The last discretionary good cause can be found when the offense is nonviolent and not drug related. They have not been convicted of any subsequent felonies. The warrant is the only one and was issued 10 months or 10 years prior to the date that SSA found out about it. And the beneficiary lacks mental capacity to resolve the warrant. So these are also pretty narrow circumstances. Good cause for not satisfying a warrant is a pretty difficult argument to make. The easier option in most of these cases is to satisfy the warrant. Now we're going to talk a bit about overpayments and underpayments while incarcerated. So overpayments can happen when somebody is incarcerated and Social Security doesn't find out about it right away. So if the systems aren't talking to each other for whatever reason, if somebody was arrested and incarcerated in a jurisdiction that's far away from the jurisdiction where their benefits office is, it's possible that Social Security won't find out about the incarceration until much later. And they could find out about it while the person is still incarcerated and terminate their benefits at that point. Or they could find out about it after they've already been released and terminate their benefits at that point and issue an overpayment in either of those cases. The way to appeal an overpayment like this is there are two ways. The first is request for reconsideration, which basically argues that it's not the overpaid person's fault that they were overpaid, and they can't afford to repay it. Fault, according to Social Security, is not the way that we talk about it in our everyday lives. Social Security considers fault to be anything that somebody should have known about. So if they find that somebody should have known that they were not entitled to payments while they were incarcerated, Social Security will find that that overpayment is their fault. So waiver is generally a pretty tough one unless there's some sort of other circumstance other than just like, I didn't know those were the rules. A better option is often a waiver, which is saying this overpayment, again, wasn't my fault and waiver is this overpayment wasn't my fault and I can't afford to repay it. Reconsideration is you're wrong about your determination. Wow, I apologize, Tuesdays. So a waiver argument is typically going to be a little bit more successful if there's something other than I just didn't know those were the rules. And somebody who is on benefits and recently released from prison or jail or still in prison or jail is very unlikely to be able to repay the overpayment. Reconsideration is a less likely option, telling Social Security that they're wrong about their determination when you in fact were incarcerated has very little chance of working. There might be some cases where it would work, but the those cases are going to be very, very fact specific. Something that's more interesting, in my opinion, than overpayments while incarcerated are underpayments while incarcerated. And this is relating back to the graphic of people who are incarcerated but not convicted. This is one area where underpayments happen. So I have seen clients on my caseload that come to me and say, I was incarcerated for 13 months, 14 months, but I was on SSDI and I was never convicted. But during that time, Social Security wasn't paying me. I'm entitled to those payments. And that is correct. The major roadblock in these kinds of cases is figuring out how somebody was incarcerated for so long without a conviction. Social Security generally requires drawing a line, mapping out what happened with that person in order for them to have been incarcerated for so long. So once we can prove that there was in fact no conviction in the case and provide official release documents to Social Security, they should issue all of the payments that would have been due to that person as an underpayment. And I think that is, one thing that Jay pointed out to me before this presentation that I did not include in my slides are fraud charges. And that is not because fraud is not a criminal offense. It is because that is not specifically my area. Fraud charges do have deep ties to Social Security, and they prevent people, when somebody is charged with a federal crime of benefits fraud, it prevents somebody from receiving benefits for the rest of their life. So this is an area where defenders and attorneys, benefits attorneys, can work together closely to try to make a deal with prosecutors to avoid conviction on a fraud charge, a federal fraud charge, to prevent somebody from no longer having access to potentially life-saving benefits for the rest of their lives. This is something we deal with. I apologize for not covering it in more depth today, but if you do have questions, feel free to reach out to me about it.
Becca, Panda Halford had a comment and a question, and she pointing out that this happens a lot with veterans benefits, that the VA receives notice that a client is incarcerated, but is often not notified when the client is released from the brick and mortar confinement versus electronic home monitoring. And it can take several months for the VA to issue a notice to the veteran that their benefits are going to be suspended. And it's on the veteran to prove to the VA that they have not been convicted or meet the definition of in custody. So all of this, again, speaks to the need to have attorneys like you guys. But the question is, does SSA consider electronic home monitoring in treatment as suspension worthy and something that would suspend benefits because you're paying for yourself if you're in your home, right? But you may still be serving a sentence.
Right. Yeah, so that is, again, it depends on the specific circumstance. Electronic home monitoring generally is not considered suspension worthy as long as the person is no longer physically confined. If somebody is in some sort of residential treatment facility, it depends on the funding source.
Okay.
That could or it may or may not be eligible for benefits.
Awesome. Okay.
Questions?
Yeah, are there more questions? And, Becca's email is at the front of this. Again, it's Becca, BECCA @benefitslawcenter.org. So she will take questions into the future, right, Becca?
I will, yeah.
That's why you're here. So if there are no questions, I'm going to just wrap it up with just a couple notes. Please spread the word to other defenders about this. Again, I found it indispensable to be connected to civil legal services folks when I'm working with a defendant charged in criminal court. It's huge because their life continues after you're done representing them. And I know you all know this. I know all your colleagues who aren't here at this webinar know this, but they can get another CLE credit for showing up again for another BLC CLE, and we will continue to do this into the future. One thing that I never wrapped, 26 years as a defender, and I never wrapped my head around the idea of how precarious my clients are, even if they're not charged with crimes. And you can imagine a mentally ill person, untreated mental illness, trying to navigate the Social Security or disability systems by themselves without an assistance of counsel. BLC, one estimate, and this is roughly, but I think in King County where we're focused, we serve something like 1,100 people in I think last year. And the estimate was there were 36,000 or 38,000 folks that needed the help, that could have used the help. So those are all those people that were gone. So BLC is kind of a tip of the iceberg program. We really, really, really win a lot of cases and do a lot of good when we represent people, but there are far more people out there than we've been able to serve. So please think about this and be sure to think about donating for this CLE, and the information's in the chat. Again, you can text to the number 44321, which is in the chat, and just text that the text message would be "give to BLC," as I think Haley has dropped in there. Or you can just go to benefitslawcenter.org on the web and donate there. And unless there are any maybe there's a last minute question here. Does BLC represent folks for these types of issues? Can we just contact you?
We do represent people for these types of issues. Feel free to refer them to our main line, and our paralegal will do a quick intake to identify the issues, and an attorney will make a decision about whether or not we can represent a particular individual.
Yes, excellent closing question. Obviously, this is why we are here, and I don't see any other questions, but I do want to just say to my comrades out there in the public defense world, thank you for the work that you guys do. It's really tough, and I know you are consumed with the day-to-day keeping your cases going and keeping your clients secure in that in the narrow focus of a particular criminal prosecution. But do think about and assist them in their efforts to carry on with their life once you're done, and once you've said goodbye to their case and they're moving on with their lives. Help them move on with their lives by sending them, communicating this information about getting the benefits that they're entitled to live on. So I will, with that, if there are no other questions, thanks again for attending. Tell your, thank you everybody. Tell your friends that this is out there. I think through WDA, this webinar the recorded webinar will be made available so that people who didn't even attend can do it, watch the recording just like other WDA seminars. You can do that online. But for those of you who've registered, you will get the link to the recorded webinar so that you can refresh your memory about any of these details that you've been given. So thank you all. Thank you, Becca. You did a great job, and we're going to sign off now. Oh, is there one more question? No, I think Eileen from Massachusetts. Thank you, Eileen, says thank you so much for this. So thank you, Eileen, for joining us, and everybody else. Take care, you.
Thank you. And thank you, Jay, for moderating.